Welcome to the module on Juvenile Justice System in India under the Juvenile Justice Act, Learning Outcome. This module aims to provide the learner with some basic understanding about the juvenile justice system that deals with children who are in need of care and protection and children who have violated criminal laws in the Indian context. It also intends to equip the learner with basic knowledge which is adequate to work within the juvenile justice system. The learner will be able to understand the salient features of the Juvenile Justice Act and its applicability with regard to children who are in need of care and protection and juveniles who are in conflict with the law. Evolution of juvenile justice system in India. The first piece of law in India which made a modest attempt to cater to the special needs of children within the criminal justice apparatus was the Offences Act of 1850. This act empowered the criminal courts to give some concession to convicted children in the age group of 10 to 18 by providing them with some vocational training which could help in their rehabilitation. Then came the Reformatories School Act 1897, which separated for the first time children from adults in the criminal justice system. Subsequently, following the recommendations of the Indian Jail Committee 1919 to 1920, the Madras Children Act 1920 was introduced. Later on, a series of provincial legislations like the Bengal Children Act 1922 and Bombay Children Act 1924 came into being. These are considered as the front runners of the juvenile justice system in India. These legislations, enacted by state governments, differed in their content and application from state to state. A central enactment called the Children Act 1960 was passed, which was applicable to union territories. With a view to bring in uniformity in the juvenile justice system, the Juvenile Justice Act 1986, which was applicable uniformly across the country, was enacted. The United Nations General Assembly adopted the Convention on the Rights of Children in 1989. India ratified the UNCRC in 1992. In order to comply with the provisions of UNCRC, the Juvenile Justice Act 1986 was amended and re-enacted as the Juvenile Justice, Care and Protection of Children Act in 2000. It was further amended in 2006 as the Juvenile Justice, Care and Protection of Children Amendment Act 2006 and in 2011. The juvenile justice system in India today is governed by this important piece of legislation. All other children acts are now repealed. A closer look at the J.J. Act will reveal that it is basically a social welfare legislation aimed at ensuring care and protection of children. J.J. Act Preamble and Definition. The preamble of the J.J. Act, an act to consolidate and amend the law relating to juveniles in conflict with law and children in need of care and protection by providing for proper care, protection and treatment by catering to their developmental needs and by adopting a child-friendly approach in the adjudication and disposition of matters in the best interest of children and for their ultimate rehabilitation. Definition of child or juvenile. Under section 2K of the J.J. Act, a person who has not completed the age of 18 years is a juvenile or a child. This definition of a child or juvenile is a consonance with the United Nations Convention on the Rights of Children. Under section 49 of the J.J. Act, whenever there is a doubt regarding the age of a person who is brought before the competent authority, it shall make necessary inquiry so as to ascertain the age of that person. For that purpose, the authority shall take any such evidence as may be necessary and shall record its finding whether the person is a child or not, stating his age as accurately as possible. Categorization of children in J.J. Act. The J.J. Act classifies children into two categories: juvenile in conflict with law, second, children in need of care and protection. Any child who violates a criminal law of the land is a juvenile in conflict with law. In the old pieces of legislation, such children were called juvenile delinquents, an expression which is no more in vogue. The J.J. Act has included into definition of the children in need of care and protection any child who is found without any home or settled place of stay and without any apparent means to lead a life. It also includes such children who reside with a person who is likely to cause harm to them. The following 10 categories of children fall under this category. First, mentally or physically challenged or ill children or children suffering from terminal diseases or incurable diseases having no one to support or look after. Second, children whose parent or guardian is unfit or incapacitated to exercise control over the child. Third, orphan children or children whose parents are unwilling to take care of them. Fourth, abandoned and surrendered children. Fifth, missing or run away children whose parents cannot be found. Sixth, children who are abused, sexually abused, tortured, or are likely to be abused or tortured. 7. Children who are forced to do illegal acts. 8. Children who are substance abusers or who are vulnerable and likely to be inducted into substance abuse. 9. Children who are likely to be abused for unreasonable gains. 10. Children who are victimized by armed conflict or natural calamity. Child Welfare Committee and Juvenile Justice Board mechanisms. The J.J. Act provides for two different mechanisms for decision making. The first one for deciding the cases involving juveniles in conflict with law, called the Juvenile Justice Board JJB. The second one for children in need of care and protection, called the Child Welfare Committee CWC. Juvenile Justice Board. The JJB, constituted under section 4 of the Act, for each district or a group of districts consists of a metropolitan magistrate or a judicial magistrate of the first class, as the case may be, and two social workers of whom at least one will be a woman. It is stipulated that persons appointed as magistrate and social workers should have special knowledge or training in child psychology and experience in child welfare. The JJB functions as a bench. A child who allegedly commits a crime, once apprehended, should be produced before the JJB within 24 hours. The J.J. Act stipulates that such a child on apprehension shall be placed under the charge of the Special Juvenile Police Unit SJPU or the designated police officer, who shall immediately report the matter to the member of the JJB. A child cannot be placed under arrest. The JJB may release such child on bail unless there are reasons to detain him or her. If bail is denied, then the JJB orders safe custody of the accused child in an observation home during the pendency of the inquiry. The procedures of the JJB are not treated as a trial but as inquiry. The J.J. Act aims at rehabilitation and social reintegration of the children who are in conflict with law. The Act expects, as indicated in section 14, that the JJB disposes of the cases within a period of 4 months, while ensuring that the juvenile does not end up becoming a criminal in the future. If the juvenile is convicted at the end of the inquiry, the law takes a reformatory approach and the juvenile may either be released on probation after counseling and admonition or be lodged in a special home or a place of safety till he or she attains the age of 18. Child Welfare Committee. Child Welfare Committee CWC under section 29 of J.J. Act is empowered to take decisions regarding child in need of care and protection. One CWC could be constituted for each district or for a group of districts. The CWC has to be formed by the respective state government. It will have one chairperson and 4 members. At least one member of the CWC should be a woman and one member should be children's expert. The CWC functions as a bench of magistrates. The CWC shall have the final authority to dispose of cases involving children in need of care and protection for the care, protection, treatment, development and rehabilitation of such children, as well as to provide for their basic needs and protection of their human rights. A child in need of care and protection may be produced before the CWC by any person like a police officer, a child welfare officer, Childline 1098, an NGO representative, any citizen or the child himself or herself. The CWC is required to complete necessary inquiry and pass an order within 4 months. Intervention strategies regarding child in need of care and protection. A. Release on probation. Section 15E provides for release of the juvenile on probation of good conduct and to place such juvenile under the care of any parent, guardian or other fit person. Such probation period shall not exceed 3 years. Institutional care. institutional care for children and juveniles under the juvenile justice system, the state government may establish and maintain the following 4 types of institutions either by itself or in association with voluntary organizations: observation homes, special homes, children homes, shelter homes, drop-in centers. The Act defines a fit institution as any registered voluntary or non-voluntary organization found fit by the CWC or JJB. Such an institution is expected to take complete responsibility of any child entrusted to its care. Any child who is in the category of the child in need of care and protection may be sent to a children's home or a shelter home or such fit institution till suitable rehabilitation is arranged. If no such rehabilitation is possible, then the child will remain in the institution till she or he attains the age of 18 years. Restoration of a child to its biological family is considered a prime objective of any children's home or shelter home. It perceives restoration of child as restoring a child to its parents, its adopted parents or foster parents. J.J. Act provides for setting up of aftercare facilities for those children who are released from institutions on their completion of 17 years of age. Such aftercare organizations are expected to take care of juveniles or the children after they leave special homes, children homes for the purpose of enabling them to lead an honest, industrious and useful life for a maximum period of 3 years or till he or she attains the age of 20 years. In case of abandoned children, infants, on receiving intimation about such a child, the police shall seek the assistance of an approved voluntary organization or a social worker and arrange to provide immediate medical assistance to the child. The child will then be shifted to a foundling home or to the care of a fit person or a fit institution. A report shall then be sent to the CWC, which will then take a decision in the best interest of the child. Non-institutional care. The J.J. Act states that repatriation and restoration are the prime objectives of any children's home. The Act also provides for certain alternatives to institutional care of children. Chapter 4 of the Act contains provisions relating to rehabilitation and social reintegration of neglected children. Special emphasis is placed on non-institutional services like adoption, foster care, sponsorship and sending the child to an aftercare organization. Adoption services. Adoption has also been included as a means of rehabilitation of children under the J.J. Act. Adoption may be resorted to for the rehabilitation of orphaned, abandoned and neglected children who are brought under the purview of the J.J. Act. The Child Welfare Committee is empowered to declare a child free for adoption and carry out such investigations as are required or giving children in adoption. Children's home and institutions run by the state governments for orphan children are recognized as adoption agencies under the Act. 2 members of the CWC have to declare the child legally free for adoption placement in case of abandoned children. In case of children who are surrendered to the CWC, 2 months period have to be given for reconsideration by their parents before starting the adoption process. In case the child is able to understand and express his or her preferences, it is required to obtain his or her consent before placing him or her in adoption. Foster care and sponsorship. A child who has been temporarily or permanently deprived of his or her family environment may be provided with foster care. The J.J. Act envisages 2 forms of foster care. First, temporary placement of those infants who are ultimately to be given for adoption in the family which is going to adopt the infant. Second, placement of the child in another family for a short or extended period of time, depending upon the circumstances where the child's own parent usually visits regularly, and eventually after rehabilitation where the child may return to their own homes. Through sponsorship program provided under Section 43, supplementary support is provided to needy families, to children's home and to special homes to meet medical, nutritional, educational and other needs of children with a view to improving the quality of life. Such sponsorship could be individual to individual sponsorship, group sponsorship or community sponsorship. The J.J. Act under Section 61 also provides for the creation of a fund either by the state government or the local authority through voluntary donations, contributions or subscriptions as may be made by any individual or organization. Such fund is for the welfare and rehabilitation of children who are dealt with under the Act. Special offences against children. Sections 23 to 26 of the J.J. Act provides for punishment for special offences against children. The following are offences under this category. First, showing cruelty to a child. Second, employment of child for begging. Third, abetment for begging. Fourth, giving drug or alcohol. Fifth, exploiting a child employee. All these offences are cognizable under Section 27 of the Act, and so the offender could be arrested without a warrant. The punishment for such offences against children attracts imprisonment for periods ranging from 6 months to 3 years and also fine. Special Juvenile Police Unit. According to the Section 63 of the Act, it is expected that in every police station at least one police officer with aptitude, appropriate training and orientation may be designated as a juvenile or child welfare officer. This officer is required to handle the juvenile or child in coordination with the police. In the Act, there is also provision for setting up of special juvenile police unit comprising designated police officials in every district and city. This provision is to enable the police officers who frequently or exclusively deal with juveniles or who are primarily engaged in the prevention of juvenile crime under the J.J. Act to perform their functions more effectively. Summary of this module. This module gives an overview of the juvenile justice system in India. It also provides some information on the evolution of Juvenile Justice Act during the last 2 decades. Module also provides the classification of vulnerable children as child in need of care and protection and juvenile in conflict with law and how they get the support of the state. Finally, module provides introduction to the decision making mechanisms in the form of CWC and JJB. Some information on intervention strategies for child in need of care and protection, special offences against children and special juvenile police unit is also given. Thank you for attending this module.